Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Now, you have been asked to come to court this morning because you have a case in this court. The case that you have in this court is a misdemeanor case. It's a criminal case. Criminal cases are divided into felonies and misdemeanors. Now, the difference between the two, your felony cases are your most serious type cases. And the reason why they're most serious is because the range of not only the offense, but the range of punishment. That is what your punishment can be if you're convicted. Now, the misdemeanor cases are commonly referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious. That is, your punishment is not as much as a felony case. For example, felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment, that is what you can get for your punishment, minimum 6 months in the state jail to maximum 2 years, and you could be given a fine up to $10,000. For a third-degree felony, the range of punishment, minimum 2 years to maximum 10 years in the state penitentiary, and a fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 20 years and a fine up to $10,000. The range of punishment for a first-degree felony, minimum 5 years to a maximum of 99 years to life in the state penitentiary, a fine up to $10,000. And for a capital murder, the range of punishment is life or death. Now, for your misdemeanor cases, misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is a fine only. That is, you only could be given a fine. You cannot be given any jail time. Now, your Class C misdemeanors are like traffic tickets, not wearing your seatbelt, your inspection sticker violations. Those cases that are normally handled in the city court, which is the municipal court, or the JP court, which is the Justice of the Peace Court. Those cases come to this court when a person files an appeal. Let's say they get convicted of one of those cases in the JP court or the city court, they file an appeal, then it comes up to here. Now, the range of punishment does not change. It's still fine only. Now, for Class B misdemeanor conviction, the range of punishment is 0 days to 180 days in the county jail. And you can be given a fine or you can be given a fine from $0 to $2,000. For a Class A misdemeanor, the range of punishment is minimum 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000. So you can be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. Now, one of the rights that the first right that I'm going to go over is your right to have an attorney. On that paperwork that you have in your hand, it has judge's explanation of rights to defendants without attorney. And on that document, it talks about your right to have an attorney. As a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. If you want to represent yourself, you may not speak to the prosecutor, and the prosecutor is the gentleman sitting at the table. The prosecutor is a person who works for the state. It's the district attorney or one of the assistant district attorney. In this, we have Assistant District Attorney Lamar Johnson. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. So if you want to represent yourself, then you have to first sign a written waiver, then you'll be able to talk to the prosecutor about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, in bold letters, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you on your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right, that means I want to give up my right to have an attorney and to represent myself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant, and you will place today's date on the line that's titled date. And today's date is November 15th of 2022. Now, for those of you who will be waiving your right to have an attorney or to giving up your right to have an attorney so that you can represent yourself, then the next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you must read this document and sign this document. Now, I'll go over this document with you. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. I have been advised this 15th day of November of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive, which means I wish to give up that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, you will sign on the line where it says defendant and you will date it today's date, November 15th of 2022. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. When a young lady is sitting in that area, we call that the jury box. 6 citizens will be selected to serve on your case as jurors. They will listen to all of the evidence. And once they've finished listening to all of the evidence is in and they've finished listening to the evidence and they've deliberated, they will decide whether or not you are guilty or not guilty. You also have a right to waive or give up your right to have a trial by jury. And by doing so, that simply means that you will not be having a jury trial. You will not be having a trial by jury. However, your case will still come before the court or before the judge in one of 3 ways. One of the ways that your case one of the ways that your case will come before the court is by way of a bench trial. A bench trial means by trial by judge only. If you desire to have a trial, but you do not desire to have a trial by jury, your case will come before the judge. So the judge will listen to the evidence, and then the judge will decide after listening to the evidence whether or not you are guilty or innocent. We call that a bench trial. Now, you also have a right to waive your right to have a bench trial. In essence, you don't want to have a trial. You don't want to have a trial by jury. You want to have a trial by judge. And so your case will come before the judge by way, if you desire to enter a plea. When I say a plea, you could either enter a plea of guilty or no contest. If you enter a plea of guilty and no contest, your case will come before the judge. And I'll just stop right there. Guilty, if you enter a plea of guilty, you're telling the court you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you will not be contesting the charges or you will not be fighting the charges. Or if you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. So if you enter a plea of guilty and no contest and you want to come to an agreement with the state, we call that a plea bargain. The state will offer you a punishment to settle your case. You can accept it or reject it. But if you accept the offer, we call that an agreed plea bargain agreement. And so if you have an agreed plea bargain, the case will come before the court, and then the court will decide whether or not it will follow or not follow the plea bargain agreement. If the court does not follow the plea bargain agreement, you have a right to withdraw, which means to take back your plea agreement. Now, if the court does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, that is to have a higher court to look at your case to see whether or not you've been wrongfully convicted or we committed an error by convicting you, then you have to get permission from the judge to appeal your case. Now, if the judge gives you permission, then your case will go to the Ninth Court of Appeals, which is right above us. They will review your case. They will decide whether or not to grant or deny your appeal. If they grant your appeal, then they can either find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny the appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. And the court that you can appeal it to that's higher than the Ninth Court of Appeals is called the Texas Court of Criminal Appeals. It is the highest court it's the highest criminal court in the state of Texas, and it's located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. And what that basically means is you will not be having a lawyer representing you, you'll be representing yourself. That's what we call pro se. And you'll be asking them to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. If you grant your appeal, hold on a minute. Hold on a minute.